SJ, welcome to Mvskoke Radio, your weekly source for tribal and community news, interesting guests and discussions, plus a local events calendar.
That would be a much more challenging argument for preemption.
Why?
For the simple reason.
Why? Because the statute doesn't contain any language about, no magic words about that either. So you either have to think that the statute does some implicit work there, or resort to some sort of Bracker balancing test? Is that what you would do?
I think it's more likely under this court's precedents to be the latter than the former.
Okay, all right, let's
so we
take
would
that.
Take the position.
Let's take that. No, I want to pursue this. Thank you. That's helpful. So you admit that the statute is silent with respect to both crimes against Indian victims and by Indian defendants, and you'd have us go to a Bracker balancing test, and you'd say it would be resolved in favor of the tribes when it comes to Indian defendants, but not Indian victims. Is that a fair summary?
The way under this court's precedents that I think the analysis would work is that once you have an Indian defendant, that obviously does implicate the right to self-governance, the right to punish tribal offenders.
So it balances differently. It balances differently. Is that fair to say?
Correct. The tribal interest would be stronger in that context.
I got it. Here's my question, why? All right? First of all, we've never applied a Bracker balancing test to criminal laws so far as I'm aware. So you're asking us to do something new there, inconsistent with our precedents so far, right?
I think that the cases on which we rely have applied it in the civil context.
Okay.
But they've never drawn a distinction.
I'll take that as a yes. All right. Then who bears the burden of proof in that balancing test?
Well, I think that the way it would work is the way that it always works on questions of preemption, which is to say it's a matter of law, and I think that the party seeking preemption would
So the tribes have the burden here. Okay.
Well, the party seeking preemption, Justice Gorsuch,
okay.
I think would
it's never going to be. It's not going to be the state. We can agree on that.
Well, that's correct.
All right.
To say
so it's going to be the tribes. All right. Fine. Then I would ask you, why would we not take into account in that balancing test you'd have us do the identity of the victim as going to tribal sovereignty, given the history in this country of states abusing Indian victims in their courts? George Washington wrote letters about this at the outset of the nation's history. In the 1920s, Oklahoma systematically used its state courts to deprive Indians of their property when oil was discovered on their lands. There's a long history of this. Congress has provided as well a mechanism for tribes who wish to opt in to state concurrent jurisdiction in Public Law 280. So that's available. We know that. They've chosen not to. Should that be something we consider? And then finally, two more things. We have the treaties, okay, which have been in existence and promising this tribe since before the Trail of Tears that they would not be subject to state jurisdiction precisely because the states were known to be their enemies. Does that count in your new Bracker balancing test, which we've never heretofore applied in criminal law? And then finally you say we have to worry about blood quantum when it comes to victims. Well, wouldn't that also be true when we have to deal with defendants? Is apparently not a worry there. I don't know why it would be a worry here. So there's a lot for you to chew on.
I think there were four things in your question, Justice Gorsuch.
At least.
Let me start with those four, and feel free to add others. First, the tribal interest here. I think that this court consistently has defined the tribal interest as the interest in punishing tribal offenders. When engaging in balancing, the court has not defined that interest more broadly as an interest in protecting victims. That having been said, obviously we acknowledge—
The treaties are irrelevant then?
Well, I was going to—
Our history is irrelevant? Oklahoma's history is irrelevant?
I was going to come to the treaties, but let me say one last thing about the interest, which is that, of course, the tribes have an interest in protecting their members from criminal offenses. The state of Oklahoma likewise has an interest in protecting all of its citizens, including its tribal citizens, who in Oklahoma have been citizens of the state longer than anywhere else in the nation. But this court has never recognized that that is sufficient, for instance, to justify tribal jurisdiction, or else Oliphant and Duro, the decisions that hold that tribes ordinarily lack jurisdiction over offenses committed by non-members, would have come out the other way. Now, you also mentioned Public Law 280 and the treaties, and I want to come to both of those because those are potential affirmative sources for preemption. And just to be clear, so that we're talking about the same framework, I think the way that the court would consider offenses committed by Indians is under some sort of balancing framework or some sort of framework that looked at whether the state law interfered with the tribal right to self-governance. Here, because that interest is not implicated, we think that the court should use a familiar approach to preemption because you're talking about competing state and federal interests. You
blithely say it's not implicated, and it's easy to say, but you have 200 years of history suggesting otherwise. And you have tribes before us saying otherwise. And you have former U.S. attorneys saying otherwise. What do we do about that?
Well, I can't speak to why the tribes have taken the position that they have in this
Counsel,
court.
It's easy enough to say that standing at the podium in Washington, D.C., but the history and the reality it should stare us all in the face. There's a reason why they've resisted jurisdiction over crimes against Indian victims. It's not just a matter of being contumacious, is it?
No, of course I'm not saying that they're being contumacious, but I would say, having spent some time in Oklahoma, that the law enforcement issues are very real. And as recently as earlier this week, you had the principal FBI agent in Oklahoma conceding that there are whole categories of crimes, by our estimation, thousands of crimes, that are going unprosecuted because the federal government, which has sole jurisdiction over this category of cases, simply has been unable to prosecute them.
Don't they have representatives in Congress? I mean, if there's crime, particularly in Oklahoma, can't they ask Congress to provide extra prosecutorial and judicial resources? Well, they can have, obviously. So my real question is this. You talk a lot about Oklahoma, and I can understand the problem in Oklahoma because of our previous case, et cetera. But aren't there 49 other states? And my impression is that in general, in the entire country, the general assumption has been, and they've acted this way for years, decades, that states cannot prosecute the specific, the particular crimes. And they don't prosecute the particular crimes when they take place in Indian country. They're prosecuted in federal court. Now, am I right or wrong? I'm not an expert, and you are more of one. So am I right or wrong about that?
So states have made efforts from time to time, I'm not going to overstate it, to bring prosecutions of this.
I didn't say that. I said the general assumption throughout the United States of America has been that the states cannot prosecute these crimes, but rather, I don't say there aren't exceptions, but rather in federal court.
I think I would quibble slightly, Justice Breyer, and say that I don't know that it was a general assumption. I think that this has been an open question. The Justice Department for many years—
How many? If you had to guess, I don't know if you've looked it up, but if you had to guess what percentage of crimes committed on Indian reservations that we're talking about here are prosecuted in state court, the crimes that are listed, what percentage of all those? Would you guess it's more like 1% or more like 50%?
I'm guessing that it has historically been a relatively low percentage, but that is in
large
part because the denominator is not that large in Indian country outside Oklahoma.
All right. Final part of the question. Okay, you're saying there are not that many, but it's been prosecuted in federal court, not state court. Now, if you win, that assumption, almost general, will be changed throughout the country. Is that right? And suddenly, the Indian tribes will realize that where they thought crimes on their reservation were being prosecuted in federal court, they will discover that suddenly, in these 49 other states, they can go into state court. Is that right or wrong? I want to just get my assumptions right. I'm not making
That is correct. And let me say a little bit about—
That is right or not right?
That is correct. And let me say a little bit about that and then about why Congress is not simply going to be able to fix this, which was where your question started.
Well, they could provide more prosecutors, is my point.
And the Justice Department has asked them to do that, but the reality is that the gap in Oklahoma right now is yawning. All we are here asking the court to do is to provide concurrent jurisdiction for the states with the federal government, which, after all, is outside Indian country, the norm in our federal system. Our submission is that this is not likely, as a practical matter, to be a significant issue outside the state of Oklahoma. There's no reason to believe that the federal government is not doing its job of prosecuting crimes in the other 49 states. What we know as representatives of the state of Oklahoma is that that is not happening in the state of Oklahoma, and you don't have to take our word for that.
Counsel, but you have a state-specific problem. At some point, I want you to address where you get your figures from. And I will lay out, there's an article in The Atlantic that suggests that your figures are grossly exaggerated, and I want to give you an opportunity to address that. But put that question aside. It may be that you're the only state that wants concurrent jurisdiction to fix a state-specific problem. But why should we assume that every other state wants that responsibility? And doesn't conferring jurisdiction on a state or telling it you have concurrent jurisdiction obligate that state in a way to protect its Indian victims? I mean, what you're saying is an unfunded mandate to 49 other states to take on a responsibility that they had a choice to take on and most of them didn't want. So we have 11 states for which Congress enacted state-specific legislation conferring some jurisdiction. In Public Law 280, again, states were given the choice. Do you want to prosecute these crimes or not? 3 more states added on to the 11. So 15 only, given a choice, wanted to do this. We are told by some amici that federal and state authorities have come to agreement in virtually every place outside of Oklahoma as to who's going to do what. But once states have concurrent jurisdiction, we are forcing the state to do something. You're saying, no, there's always prosecutorial discretion. But is that true? They have an obligation to treat their citizens equally. Having said that, this is not a case. What you're doing is putting all of those 15 laws conferring different kinds of jurisdiction on those states into question. You're throwing out those 15 agreements and you're saying, forget what they say about limiting state jurisdiction or not. States had an inherent power to do this. Maybe you'll come back and say, well, those are agreements, so they're still bound by them. But now you're creating chaos across the country, 49 other states. And I am told that the federal government decides whether to put some resources in some places based on what kind of jurisdiction exists with the states and not in others. All of that is up in the air. So please explain to me why 200 years later we are revisiting an assumption that was made. You say it was only dicta, it was never decided, but we have an awful lot of dicta on this issue, repeatedly in many, many cases.
Justice Sotomayor, there's a lot to that question, and let me try to cover all of it. First of all, with regard to the statistics, we believe that the statistics that we have offered to the court are accurate, but you don't have to just take our word for it. To get back to Justice Breyer's question, let's take a look at what the Justice Department has said in its most recent 2023 budget report. It has said, quote, the United States attorneys in Oklahoma are prioritizing violent felonies under the Major Crimes Act. In fiscal year 2021, the Eastern District of Oklahoma and the Northern District of Oklahoma are opening only 22% and 31% of all felony referrals. Enforcement of nonviolent crime is relatively low. And if we want to talk about what's been said...
most of that is being done by the tribes, isn't it?
Well, not with...
I see a short gap of the Atlanta article says at most there's a short gap of about 1,000 cases. If that...
We don't agree with that. It's important to keep in mind that the tribes do not have jurisdiction over this category of cases with narrow exceptions. And if we're going to litigate what's been said in the press, I would refer the Court to the Wall Street Journal article earlier this week, to which I alluded, in which the special agent in charge of the FBI's Oklahoma field office said, quote, the United States Attorney's Office doesn't have the capacity to try nonviolent felony, my words, or even any misdemeanor cases. Now, I do want to cover the other points that were in your question, which I think are really important. First of all, with regard to supposedly foisting this authority on the states, let's keep in mind the fact that the states do enforce the criminal laws already in Indian country by virtue of the rule first established by this Court in McBratney. When non-Indians commit crimes against non-Indians in Indian country, law enforcement is there, state law enforcement is there, because they have exclusive authority in order to enforce the criminal laws.
Several states have renounced the very kind of authority you thrust upon them, though, haven't they?
Well, it is true that a very small number of states have renounced the additional authority provided under Public Law 280, but that brings me to the Public Law 280 regime, Justice Sotomayor. And there are a couple of things I would say about that. First is just the fundamental oddity of the position on the other side, which is that a statute that by its terms conferred additional jurisdiction should be viewed as ousting all other pre-existing jurisdiction. And the reason that we know that that is not the law is because this Court said so in 3 affiliated tribes 1, when in the civil context it said, quote, nothing in the language or legislative history of Public Law 280 indicates that it was meant to divest states of pre-existing and otherwise lawfully assumed jurisdiction.
In a civil case. We were very clear in saying criminal cases are different from civil
But the
cases.
reasoning, Justice Sotomayor, is exactly analogous, and let me explain why. Public Law 280 confers on states essentially plenary civil and criminal jurisdiction, either states that are the mandatory states or states that opt in. And you could make exactly the same argument in the civil context with regard to civil actions brought by Indians against non-Indians. And yet this Court made that statement in the context of whether or not Public Law 280 should be used to construe a state law as ousting the state of pre-existing jurisdiction. Our submission is that Public Law 280 operates perfectly well under our interpretation. What Public Law 280 does is to confer this broad array of additional jurisdiction, not just a plenary civil jurisdiction, but of course criminal jurisdiction, including jurisdiction over offenses committed by Indians, which appears to have been Congress's principal concern when it enacted Public Law 280. Now, to be sure, the text of Public Law 280 also clarifies that states that participate in or opt into the regime will also have jurisdiction over offenses committed against Indians. But there's nothing odd about that.
Let's talk about that for a second. I'm not so sure. First of all, you agree, though, that in 1948 when Congress passed the GCA, the text of it is consistent with the conclusion that Congress believed the states generally lacked prosecutorial authority over crimes committed by non-Indians against Indians in Indian country, right?
Some members of Congress plainly believe that because there is evidence in the legislation.
No, more than that. You agree that the text is consistent with an understanding that Congress thought that, right?
The text is consistent both with my position and with my friend Mr. Schaaf's
Okay. If the text is consistent with the opposing position, then let the Public Law 280, the Kansas Act, the North Dakota Act, the New York Act, the Iowa Act, all adopted in years immediately preceding and immediately following the GCA, expressly confer criminal jurisdiction on certain states, just doesn't happen to be Oklahoma, for the very kind of authority at issue here, expressly, right?
Yes, but at the same time, none of those
all
laws,
of that would have been pointless, right?
No, not at all.
No need to say you have state criminal jurisdiction in crimes involving Indian victims.
It's perfectly reasonable, particularly in Public Law 280, Justice Gorsuch, for Congress to have wanted to clarify that the states had that pre-existing jurisdiction.
So it's belts and suspenders, on your view?
Well, to a certain extent, but I don't think that there's anything strange about that, because Congress often passes statutes that do nothing more than codify pre-existing legal principles. Here,
then how about the
more.
fact that we have, in my count, 10 cases stretching from 1832 to 2 years ago saying that states don't have this kind of jurisdiction? You call it dicta, all right? But even in your very best case, McBratney, Draper, the cases you cite and rely on, the Court reiterates that it is not talking about and is not extending jurisdiction over these kinds of cases. What do we do about that?
I don't think that's quite correct. I would recognize, Justice Gorsuch, that by my count there are 6 cases, starting with Williams versus United States.
I might go back to Worcester. I think you might be missing a couple.
I don't think that that's a fair characterization of Worcester, because Worcester was simply stating the principle.
All right, we can quibble over the number, all right? I think your count's a little parsimonious, but whatever number it is, it's a large number. And even the cases you rely on most heavily carve this out. What do we do about that?
I don't think that's correct, and let's go directly to McBratney. I think that all that the Court said in McBratney was that it was not deciding any question under the provisions of the applicable treaty with regard to crimes committed by or against Indians. I think the reasoning of McBratney strongly supports our position, because McBratney...
But it carved that question out. It carved this question out and said it wasn't going there.
I don't believe that that is correct.
All
I
right.
believe that the Court only started to carve out the question in Donnelly. And I think what happened is...
Then how about this? How about Oklahoma's own position for the last 30 years, which it has taken the position, since I understand at least 1990, that is the correct understanding of the law. That has been the Justice Department's understanding of the law. Don't we normally, when we're thinking about an old statute, give respect to how it's been liquidated and understand it by all 3 branches of government consistently, maybe the state itself, who might have had an admission against interest back when nothing was at stake, but now changes its view?
I think what I would say about the federal government, Justice Gorsuch, is that their position by their own recognition has certainly not been consistent, and I would refer the Court to the 1979 OLC opinion and the government's subsequent statements, where the government has suggested that when it comes to the sort of interest balancing that we were discussing earlier, Justice Gorsuch, that interest weighs in the state's favor.
Do you care to address your own client's positions?
I'm very happy to address Oklahoma's position. The practical reality, of course, was that this was not a significant issue before this Court's opinion in McGirt.
Exactly. And shouldn't that count for something?
Well, no. I think that what it should count for is that this has suddenly become a major problem in Oklahoma. And to be clear, the reason that we are here today is because of McGirt. This was not a significant law enforcement issue in the state of Oklahoma, for the reason that the government acknowledged in its earlier briefing in the McGirt line of cases, which is that in Oklahoma, there is very little trust or reserved land. Most of the land is fee land, like the land in downtown Tulsa and the other cities in the eastern half of Oklahoma, and therefore would not have been thought of as Indian country. Now, I think with regard to Oklahoma, the history, as you are well aware, is somewhat complicated in this regard, because there was a lengthy period of time when the Oklahoma Court of Criminal Appeals, in fact, said that the state had plenary criminal jurisdiction even over Indian country in the state, and the Oklahoma Court of Criminal Appeals eventually reversed that position. And so I think it's very hard to say that there's a lot of data about what the state of Oklahoma was doing. But I will grant you that I can't point to a prosecution by the state of Oklahoma after 1990. I would just say that that's consistent with the fact that this was not a significant issue because of the relatively small amount of Indian country. Now, I do want to...
Mr. Chairman.
Please. Why don't you wrap up quickly, and Justice Kagan will have your question, and then we'll move on to the next stage.
I'm happy to take my turn in order.
Go ahead.
Great. Go ahead, Justice Kagan. I wanted to say one more thing in response to Justice Gorsuch, but...
Okay, you'll find a way to fit it in, I'm sure. I want to talk about the text of the statute for a few minutes and just start with this question. Is there concurrent jurisdiction on federal enclaves?
No.
Yeah. And, I mean, I look at this text, and, it's not the clearest statute for either side of the table here. But if I ask myself, like, what does this text really mean? And mean back when it was written, not today, given the history from which it emerged. I mean, the idea that this statute did anything other than analogize to federal enclaves in the entire sense, meaning it's the law that in federal enclaves, and it's the exclusive law of the federal government. I mean, it just seems to me the more natural reading of the statute in its historical context.
I don't agree with that, Justice Kagan, and I don't think that the statute is ambiguous, and I assume that we're talking about the General Crimes Act, and I will come to Public Law 280 in a minute, but I think with regard to the General Crimes Act, what I would say is what this Court said in Henry Wilson. With regard to this phrase, places within the sole and exclusive jurisdiction of the United States, what the Court said was that phrase does not apply to the jurisdiction extended over the Indian country, but is only used in the description of the laws which are extended.
I don't think I'm really talking about this as a matter of parsing the sentence and applying rules of grammar to it. I think what I'm talking about is the sense of the provision is to say the only thing the provision does is to analogize to federal enclaves. And then the question becomes, what's the law in federal enclaves? And the law in federal enclaves is exclusive federal law. I mean, it's a kind of bizarre thing that Congress would have done, isn't it? To say, well, we're going to have federal enclave law applying, and then we're also going to have state law applying. This is not like federal and state law apply in the state of New York or something, right? Because federal enclave law is essentially law that duplicates the kind of subjects in which state law is concerned. And so you have two bodies of general law operating in the same geographic area. Now that now and that then is kind of odd. And like, why would we think that that's what Congress did when it said in this statute, look to federal enclaves?
I don't think that that's odd, Justice Kagan, either as a matter of text or as a matter of history. So as to the text, our fundamental submission here is that when you look at the structure of that sentence in Section 1152, it provides simply that the general laws of the United States as to the punishment of offenses committed within federal enclaves shall extend to the Indian country. And I think that as a matter of structure and plain language, that suggests that what you're talking about is the substantive criminal laws of an area that is within the sole and exclusive jurisdiction of the United States, federal enclaves.
Go ahead.
If you don't agree with me on that, I would point to the history here, and this goes really to, I think, Respondent's core argument. Respondent sets great store by the 1834 enactment of the predecessor to the General Crimes Act. But, of course, in 1834, to the extent that Congress was thinking about the principle of territorial separation from Worcester, the first of the cases to which Justice Gorsuch referred, Congress incorporated that in its definition of Indian country, which is, after all, the trigger for what is now the General Crimes Act, by defining Indian country to exclude territory within the borders of states. So Congress didn't have any occasion to think about the preemption question that's presented here. That question was effectively moot because the statute only applied to territories outside state borders. And when you think about our country in 1834, obviously that was most of the territory west of the Mississippi River for starters. And I would parenthetically note that is that both the text and the history are reasons to distinguish the General Crimes Act from the Major Crimes Act, though I think the right way to think about the Major Crimes Act as a matter of first principles would be to think about it in preemption terms like the way that Justice Gorsuch and I were discussing earlier, and not so much in terms of the text.
I mean, I wonder if all of that cuts for you or against you. I kind of think the latter. I mean, here you are in the 1830s, coming after Worcester, with a sense of the history of states operating against tribes and tribes needing federal protection. And, as I said, I think that this statute is not grammatically pristine, and Mr. Schauf has an argument and you have an argument, but given two alternatives, given that history, why we shouldn't read it as essentially saying, go do the same thing in Indian country as you do in federal enclaves, rather than go do this completely weird thing where reservations or Indian country is going to have two bodies of general law, including state law of the states that tribes needed protection from the federal government against. I don't know why you would pick your
Well, my first-line response, Justice Kagan, is that this Court has already construed this language in Wilson and, again, in Donnelly.
Well, I don't know if you get to talk about precedent, because you're up here and 6 times we have said the exact opposite of your position. And you say, well, it's dicta. But it's not normal dicta. It's in 6 cases, this Court has laid down the jurisdictional rules and has specifically rejected your position. So, in terms of what this Court has said, I'm sorry, but this Court has indicated 6 times that you're wrong. Congress has indicated that you're wrong, given its consistent enactment of statutes that make no sense in light of your position, Public Law 280 and the state-specific ones. The executive branch has said that you're wrong in all but 1 decade. You're asking us to do a big lift on the basis of language that, as I say, seems to me more naturally read against you.
I respectfully disagree with that, Justice Kagan, and just a couple of additional points. I think with regard to the issue of dicta, I would say that the statements on this issue, starting with Williams versus United States, are, for lack of a better way of putting it, on the dicta end of the dicta spectrum. You're talking about no more than 2 sentences in any of those decisions. Those statements were really not essential in any way to the holdings. I would submit that the statements in Wilson and Donnelly were much more to the core of the questions that the Court was considering. We're talking about cases like Solem and Bryant on the other side, where the Court is simply stating the principle that Respondent is advocating in passing on its way to dealing with very discrete questions such as diminishment of reservations and the validity of the federal recidivist statute that takes tribal convictions into account. So I do think that with respect, we're entitled to point to this Court's precedent, not least because this Court's precedent involves interpretation of the 2 statutes on which Respondent relies. And with regard to Public Law 280, the one thing that I wanted to say in response to Justice Gorsuch, because that is, after all, the other statute on which the other side relies, is that when you start to frame the argument in terms of Public Law 280 occupying the field and the like, that starts to feel like a field preemption argument. And I think Respondent almost goes there in his brief because he relies on cases like Virginia Uranium and Hines, but he doesn't use the words field preemption, and I would submit that that's for good reason, because Public Law 280 would far short of the standard for field preemption, not least because, as this Court indicated in 3 affiliated tribes, there's no indication in Public Law 280 that Congress intended to oust the states of pre-existing jurisdiction.
Thank you, counsel. I have just one question. We've heard a lot about McGirt this morning, and I understand your point that it has sort of upped the ante on the question before us today. But is there any way in which the analysis in McGirt affects the point you're trying to make, or is it just kind of a background fact?
The practical realities of McGirt are relevant, Mr. Chief Justice, on this question presented, primarily if this Court decides to engage in a balancing of interests, because in weighing the state's interest and the propriety of concurrent jurisdiction. I think it's entirely appropriate for the court to take into account what is going on in what is now the largest piece of Indian country by area and population in the United States.
I mean, in terms of how we analyze the General Crimes Act, how we analyze Worcester against Georgia, the other sort of legal authorities at issue here, McGirt doesn't offer any guidance in that analysis, does it?
No, these are fundamental, familiar preemption questions, and particularly because this case does not implicate the tribal interest in punishing tribal offenders, this is really a case that pits state interests against federal interests. And just to be clear, what the federal government is here saying, and my friend Mr. Needler will be at the podium shortly to say this, is that the federal government should have exclusive jurisdiction here. And I guess I'm at a loss as to why the federal government would take that position when federal officials, both in statements to the public but also in statements to Congress, is acknowledging this massive prosecutorial gap. Thousands of crimes, however you do the statistics, that are going unprosecuted by the federal government in the state of Oklahoma.
Well, I mean, so really, at the end of the day, when you're talking about McGirt, you're really just waving the bloody shirt. It doesn't have any direct pertinence on the legal analysis here.
This is an extraordinary situation, I think, unlike any situation in recent history, where what's going on right now in Oklahoma is a giant law enforcement experiment. You have almost half of an American state now, at least as to this category of crimes, under the exclusive criminal jurisdiction of the federal government, and the federal government is failing in that task. And I don't think that the court should bind itself to that. Now, to be sure, the question that is presented here will affect only by the federal government's own estimation around 20 to 25% of the crimes affected by this court's holding in McGirt. And as the court is well aware, the state of Oklahoma has asked this court to revisit its earlier decision in McGirt. That's an extraordinary step, but these are extraordinary circumstances. And I would submit that if the court decides this question presented against the state of Oklahoma, it's only going to exacerbate what is already an extraordinary situation. And at that point, the court may want to revisit its judgment not to reconsider McGirt at this time.
Thank you. Justice Thomas? Justice Breyer?
I think tell me if you have general thoughts on this. I mean, the sort of philosophical thing that is occurring to me is that you're sort of winning the game once you or not winning it, but strengthening your argument once you use this word preemption. But Indian tribes on Indian land are not states. And they are, what's the phrase, sovereign dependent nations? So I don't know quite how that pans out. But the other thing which is more important, which I'd love any comments you have on it, given your whole experience in many areas of law, can you give me a phrase or a word or a view in your mind of what weight this court should give to such a fact as virtually unanimous across the country assumption that the law was X? Is it totally irrelevant? Or is it a little relevant or a lot relevant? How do you think about that in general?
There are familiar doctrinal frameworks, Justice Breyer, and by definition your experience
I'm
is
asking for
broader
your
than mine,
view,
but
because you have many cases, you have much experience in the area, and I think that's I guess you don't have to answer it, but I would be curious.
I'm happy to answer it directly. There is a word for it, Justice Breyer, and that word is ordinarily ratification. In other words, that is the doctrine that this court ordinarily uses to embed in statutes that might otherwise be silent pre-existing understandings from interpretation. But again, that's another word that you can search respondents' brief for in vain. Mm-hmm. And I think that that's for good reason, because if the argument here is ratification.
No, I'm not interested in ratification.
Well, but that is
because we have cases where the law in many, many areas, even with leaving Congress out of it, some might think, has been X. But it's argued in front of us, no, even though everyone thought it was X, everyone was wrong. It was not X. Now, assuming that's a situation, my same question, what weight do we give to the view that everybody did think it was X, or nearly everyone.
I'm happy to confront that directly. So the one thing I think everyone agrees on before this Court is that this is a question of preemption. And I would note that nobody is here arguing that in this context the balancing approach from Bracker or other cases should apply. I think everyone recognizes that this case involves the familiar approach to preemption where you look to whether or not federal law displaces state authority. Everyone also agrees before this Court that the only relevant source of federal law is statutes because, Justice Sotomayor, there's no argument here that there's any treaty by its terms that has preemptive effect. And so then the question becomes, what is there in the statute that preempts? And there's a statutory interpretation component to that. Now, we would say that the first and last place you look is to the text of the statutes, and everyone agrees that there's nothing on the face of the statutes with the exception of this potential argument with regard to the phrase sole and exclusive jurisdiction that preempts. And if you don't accept that argument, then what you're left arguing is making arguments based on background understandings. And we really have two of those arguments in this case. An argument with regard to the 1834 predecessor to the General Crimes Act that it embedded the principle of territorial separation from Worcester, or an argument that the 1948 recodification, which after all was just the recodification in the United States Code without substantive change, somehow ratified this Court's interpretation in a single sentence of text in its dicta in Williams at a time when the law was unsettled. That would come nowhere near this Court's standard for ratification, which is why I suspect Respondent doesn't affirmatively invoke that doctrine. And I think with regard to Worcester and the background understanding, this Court has long retreated, as has Congress, from the hardline view of territorial separation. And if that were not true, then this Court would have to revisit decisions like McBratney, Draper, and more recently Nevada versus Hicks, all of which have given the states broad law enforcement authority in Indian country in the criminal context. And so with respect, I think what you're really left with on the other side is some sort of mosaic theory. If you take a look at page 28 of the government's brief, the government says, well, there's a pattern of congressional enactments. But with all due respect, I think that that's a lot like Justice Gorsuch's steak rub. It's not entirely clear exactly what the government and Respondent is relying on here in the absence of
that's because there's so much.
Mr. Shamandam, if you could continue.
I don't agree with that, Justice Kagan, for the simple reason that when we're talking about congressional enactments, which after all, again, is the touchstone because we're talking about a question of preemption, there are really only two options here. There's either the General Crimes Act itself or there is Public Law 280 and the accompanying state enactments. And I think that Public Law 280 is the harder of the two for the other side for the simple reason that not only has this Court addressed a nearly identical issue in the civil context in 3 affiliated tribes, but that is a statute that by its terms only gives states additional jurisdiction, and I think it would be passing strange to construe it as divesting all of the other states of their pre-existing jurisdiction.
Thank you. Justice Alito, anything further?
Well, the Chief Justice asked you about the relevance of the Court's reasoning in McGirt, and there have been questions raising the possibility that dispositive weight should be given here to what some people may have assumed was the answer to the question presented in this case. What weight did the Court give in McGirt to what had been assumed for a period of time about the status of the territory in question in that case?
Well, I do think that it is slightly ironic that the history of non-prosecution has been cited against the state of Oklahoma when the Court in McGirt didn't attach any weight to the settled understanding for that period of 100 years about the status of the eastern half of Oklahoma. And just to be clear, I'm not here today to relitigate McGirt. Our submission is simply that the problems created by McGirt are extraordinary, as this Court, as some members of this Court predicted at the time of McGirt, and as the federal government in its brief in McGirt said was going to be the case with regard to criminal jurisdiction in particular. And with respect, I do find it slightly astonishing that in its entire brief, the government says nothing about the current state of affairs on the ground in Oklahoma in this area in which it has exclusive jurisdiction. Perhaps my friend Mr. Kneedler will speak to that today. But again, it seems to me that that is very relevant context as this Court is deciding the question that's before it.
These were the presentation, the oral argument by the state of Oklahoma's attorney, and the case of Castro Huerta versus Oklahoma. Now, Victor Castro Huerta is a non-Indian who's tried in state court, upon which he received a state conviction of child neglect and a 35-year prison sentence. The crimes committed were against a minor enrolled in a federally recognized tribe inside the Cherokee Nation reservation. Next week, we will follow up in part 2 of this program with the presentation and oral arguments from the tribal attorneys and points they're making. News reports from the nation's capital expect a decision by the end of June. Okay, a couple of quick announcements here, and we'll wrap this up for today. We are calling for submissions. The 2022 Mvskoke Creek High School Military, Technical, and College graduates for the June 1st edition. Sunday, May 15th at 5 p.m. is the deadline for our special June print edition. Once again, Sunday, May 15th at 5 p.m. is the deadline. Profiles will be edited for Associated Press Style and Grammar and such. The profile should include a high-resolution digital image, a name, high school, that program you are graduating from, 150-word bio limit. Now, once again, May 15th at 5 p.m. Late profiles will not be accepted. We cannot stress this enough. The information, 732-7720. And email stating your submission has been received will be sent to you. However, if you don't get a response, please call and verify your information was received. So once again, we'd love to include you in that special June 1st print edition. The deadline is Sunday, May 15th at 5 p.m. Okay. Let's see what else might we have. The Living Legends ceremony is still accepting nominations, and that will be taking place at the River Spirit Resort in Tulsa on June the 23rd. So if you've got some information, you want to contact 732-7605. Okay, I think that'll do it for me. You've been listening to Mvskoke Radio. Join us again next week for more local, tribal, and community news and updates. Mado.